Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Chicago, Illinois, Class 1. Felony lawyers. Being accused of, arrested for, or charged with a Class 1 felony in Chicago, Illinois is a very serious matter. Class 1 felonies carry the most punitive non-Class 10 felony punishments under Illinois law. A conviction can mean hefty fines and long prison sentences. If you're facing a Class 1 felony charge in Chicago or anywhere in the Cook County area, the criminal defense lawyers at Combs Waterkotte can help. We'll fight to keep you out of prison and minimize the impact of your Class 1 felony charge on your life. Class 1 felony lawyers in Cook County and Chicago, Illinois. Facing a Class 1 felony in Chicago is a very stressful experience. These charges come with mandatory minimum prison sentences and potentially decades behind bars, depending on the circumstances. You need a Chicago-based criminal defense attorney on your side who understands how to handle this process and who will fight hard for you every step of the way. At Combs Waterkotte, your case isn't just a number to us. We treat each and every client with the same level of focus and determination. This client-centered approach means we'll keep you informed about every step of your case from your very first consultation. Through our combined 6+ decades of legal experience, we've learned the ins and outs of Illinois criminal law. We know the local Chicago courts, we've worked with prosecutors in the area to negotiate plea agreements, and we're always ready to go to trial if we have to. If you live in the Chicago or Cook County area and you're ready to start fighting your Class 1 felony charges head-on, reach out to Combs Waterkotte online or give us a call at 312-500-HELP. Take the first step toward fighting for your freedom and future today. What is a Class 1 felony in Chicago, Illinois? Under the Illinois Compiled Statutes, ILCS, Class 1 felonies are the next most serious category of felony offenses, besides Class 10 felonies. The punishments for Class 1 felonies depend on factors like prior convictions, amounts for drug and theft crimes, injuries, or the use of a weapon. But generally, penalties include a prison sentence between 4 and 15 years, 15 to 30 years for an extended term, fines up to $25,000, mandatory supervision for 2 years after release. While the standard prison sentence for a Class 1 felony conviction in Chicago, Illinois is 4 to 15 years, some offenses may warrant an extended prison sentence between 15 and 30 years. These extensions come solely at the discretion of a judge and are based on aggravating factors like committing a Class X or another Class 1 felony within 10 years of a previous Class 1 felony conviction, crime committed with exceptionally brutal or heinous behavior, like beating a victim repeatedly with a weapon, starving or severely neglecting a child, execution-style gunshot murder, committing a crime against a vulnerable victim, like a child under 12, a person with a physical disability, a person 60 years or older, group-based misconduct like torturing animals or humans, kidnapping, stealing human corpses, gang offenses, the use of a firearm with a laser sight, using an animal to attack police officers, common Class 1 felony offenses in Chicago, Illinois. There are several criminal acts that constitute a Class 1 felony under Illinois law. One of the easiest ways to understand these offenses is to group them into categories. Here are some of the most common Class 1 felony offenses in the Chicago and Cook County area, categorized into offense types. Drug crimes. Under the Illinois Controlled Substances Act, there are several drugs for which you can be sent to prison even for having them in your possession. Drug crimes in Chicago span the felony spectrum from Class 10 to Class 4 felonies, but a couple of the most common Illinois Class 1 drug offenses we see at Combs Waterkotte are manufacture or delivery of controlled substances for moderate amounts of heroin, fentanyl, cocaine, peyote, methamphetamine, and more substances. Possession of controlled substances for certain amounts of heroin, cocaine, morphine, peyote, LSD, methamphetamine, and more substances. Sexual crimes. There are quite a few sex offenses that qualify as Class 1 felonies under Illinois law. Prosecutors in Chicago tend to pursue convictions in these cases very aggressively. Some of the charges we see filed most often include criminal sexual assault for first-time offenders, aggravated criminal sexual abuse when the offender is 17 years or older and the victim is 17 years old or younger, child pornography for still images. Possession of child pornography videos is a Class X felony. Weapons crimes. Illinois has some of the most strict firearm ownership laws in the United States. As such, offenses committed with firearms in Chicago come with heavy felony penalties. Here are some of the most frequent, for which Combs Waterkotte provides a criminal defense. Unlawful use of weapons by a felon for repeat offenders. Aggravated discharge of a firearm for shooting at a person or a building or vehicle the perpetrator knows is occupied. Escaping from police custody when the escapee is armed with a dangerous weapon. Violent crimes. Police and prosecutors tend to take a particularly tough stand against violent offenses, seeking the maximum possible prison sentences allowed under the law. Many violent offenses in Illinois are Class 1 felonies, but the most common we help defend against in Chicago include second-degree murder, aggravated battery when causing great bodily harm or strangling another person with a dangerous instrument, aggravated intimidation when committed in the furtherance of gang activity. Property and theft crimes. Stealing and theft crimes in Chicago and the Cook County area can easily amount to Class 1 felonies if the offense reaches certain value thresholds. Here are some of the property and theft crimes charges we see brought most frequently in Illinois. Theft for a value between $10,000 and $100,000 for property stolen from a school or church, and for a value between $100,000 and $1 million for any other property. Burglary when committed in a school, daycare center, or church. Identity theft for a value between $10,000 and $100,000, or a value between $2,000 to $10,000, where the victim is in the U.S. Armed Forces or Illinois National Guard. Financial institution fraud for a value between $100,000 and $1 million, with the loss of possible probation for values between $500,000 and $1 million. Criminal defense strategies for Class 1 felony charges in Chicago. While Class 1 felony offenses in Chicago, Illinois are very serious, an experienced criminal defense lawyer can still develop sound legal strategies to combat many of these charges. Here are some of the criminal defense strategies we use most often at Combs Waterkotte to contest Class 1 felony charges in Chicago. Fourth Amendment violations, illegal search and seizure. In many Class 1 felony cases, especially drug offenses and weapon charges, the prosecution needs good physical evidence for a conviction. A defense attorney may be able to challenge whether or not law enforcement conducted an unlawful search or seizure in violation of the Fourth Amendment. Lack of intent. Oftentimes, Class 1 felony charges, like a drug delivery, financial crime, or aggravated battery, requires intent on the part of the defendant. As a result, prosecutors have to prove that intent. A defense attorney, on the other hand, may be able to argue a lack of intent, showing that the defendant did not knowingly or purposefully commit the alleged act. This is relevant in cases involving misunderstandings, accidental conduct, or situations where the defendant's role was misinterpreted. Self-defense. In violent Class 1 felony cases, a defense lawyer may argue that their client acted in self-defense. Illinois law allows individuals to use reasonable force to protect themselves from imminent harm. If a defendant reasonably believed force was necessary to prevent injury, this can serve as a good defense against the charge. Defense of others. Similarly, this argument applies when a defendant uses force to protect another person. In Class 1 felony cases involving fights, a defense attorney can argue that the defendant intervened to prevent harm to a third party. The key issue is whether the force used was reasonable under the circumstances. If it was, the charges may not stick. Entrapment. This defense is powerful in Class 1 felony cases involving undercover operations, such as solicitation or controlled substance offenses. If law enforcement induced or persuaded a defendant to commit a crime they otherwise would not have committed, a defense attorney could argue an entrapment defense to get the charges reduced or dismissed. Duress. For certain Class 1 felonies like drug crimes or theft crimes, a defendant may claim they acted under duress. This means they were forced into committing the crime due to an immediate threat of harm, leaving no reasonable legal alternative. This defense can be especially relevant in cases involving gang pressure or threats of violence. Fifth Amendment violations. Self-incrimination. Statements made by the defendant can play a major role in Class 1 felony cases in Chicago. The Fifth Amendment protects individuals from being compelled to incriminate themselves. A defense attorney may be able to argue that police officers obtained statements improperly through coercion, prolonged interrogation, or pressure. Miranda rights violations. When a person is taken into custody, law enforcement must inform them of their Miranda rights, including their right to remain silent and the right to an attorney. If police fail to advise a defendant of these rights properly before conducting an interrogation, any statements made during that interrogation may be excluded from evidence. How a Class 1 felony lawyers in Chicago can help you. A skilled Chicago criminal defense lawyer can evaluate the charges against you, identify weaknesses in the prosecution's case, and develop a strategy tailored to your situation. From the outset, they work to protect your rights, explain your options, and help you make informed decisions during every stage of the legal process. An experienced attorney can also challenge the evidence presented by the prosecution, including questioning the legality of searches, arrests, and interrogations. By filing motions to suppress unlawfully obtained evidence or statements, a defense lawyer may be able to reduce the strength of the prosecution's case significantly or have key evidence excluded altogether. Beyond the courtroom, a defense lawyer can negotiate with prosecutors to seek reduced charges or more favorable outcomes when appropriate. Whether pursuing dismissal, negotiating a plea agreement, or preparing for trial, their goal is to minimize potential penalties and help you achieve the best possible result in your criminal case. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.